And we're going to proceed with trial. So please put yourself back in front of the camera. Follow the court's order, or you could be found in contempt. I don't want to do that.
Regardless of an individual's claimed status of descent, be it as a sovereign citizen, a secured party creditor, or a flesh and blood human being, that person is not beyond the jurisdiction of the courts.
Ground to dismiss this case, and we would ask that this court.
I object, Your Honor. I'm disputing my birthright. I'm disputing my right to travel.
All right, I got it. All right,
This is the City of Detroit versus El Rico Gator. Case number SP 128-1837, counts 1 and 2. SP 156-07261, SP 162-4983, counts 1, 2, and 3. SP 164-3083, counts 1 and counts 2 in the state of Michigan versus El Rico Gator, case number SX 40380982. Appearance for the record, please, Mr. Barrett.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Gator.
I'm speaking for the corporation of El Rico Gator.
They're gonna love this one. Good morning to you, Mr. Gator.
Good morning.
All right, today is the date and time, so I kind of got to get an understanding of, we need Mr. El Rico Gator. We don't need the corporations of El Rico Gator. How do we find Mr. El Rico Gator?
I guess that's the name I was given. I guess I'm El Rico Gator.
Okay, all right. Today is the day. Now let me ask you this: do you want Mr. Barry to represent you, or do you want an attorney to represent you?
Yes.
Okay, good. All right. All right. So today is the date and time set for. It's some matters under warrant status, Mr. Berry, and other matters are in pretrial for the purposes of the warrants. Mr. Berry.
Your Honor, we would waive the reading of the information and stand mute.
And we'll enter a not guilty plea on your client's behalf and give your client a $0 bond. So what I have here is 1, 2, 3, 4 tickets in Mr. Gator's name. And then I counted some other tickets into the record. I can give you those tickets whenever you're ready.
Ready, Your Honor.
I have a driver's license suspended. I have a no insurance misdemeanor. I have a no ops. I have a failure to stop and an improper turn. So it should be 1, 2, 1, 2, 3, 4, 5, 6, 7, 8, 9 cases I called into the record.
Yes, Your Honor.
2 of them are civil infractions that were in default. I have no problem setting these defaults aside. They were kind of a little bit back in October, but since I just said it, I don't have a problem setting an improper left turn and a failure to signal at a stop sign or whatever that is, if the city has no objection to hearing you.
No objection, Your Honor.
Give Mr. Gator an updated offer. I also see a no insurance, the insurance no proof 288. If Mr. Gator is interested in getting a valid driver's license, he probably want to pay that 288. At least get a port of clearances here at the 36th District Court. That's the only thing I can see affecting Mr. Gator's license. Mr. Gator, what I'm going to do is I'm going to put you in a breakout room with Mr. Berry. Have a conversation with him. Let us know what you want to do when you come out, okay? What happened to Enrico Gator?
Maybe his corporation said he had a board meeting.
He had a board meeting. All right, let's pass it. All right, are we ready on someone, Mr. Gator? Let's go back on the record with Mr. Gator. Mr. Gator, I'm giving you an opportunity to speak to counsel. Counsel, what's your client want to do?
We seek a bench trial date, Your Honor.
Is that what you want to do, Mr. Gator?
Yeah.
March the 10th. Come back March the 10th at 9 a.m., all right?
All right, I got one question, Your Honor. He not gonna be representing me, is he? Because I don't want him to represent me.
Well, listen, Mr. Gator, see, this is how it works. If you want to pick your attorney, you got to pay for your attorney.
All right, that's fine. That's fine. That's fine.
You got another attorney in here. We'll always have 2 attorneys in here on that date, though. All right.
All right.
Best of luck to you, sir. Have a very good rest of your day.
You too.
Mr. Robinson, are you here?
I am here representing the name, ma'am.
All right, you need to start your video, please. And you are, is it Tremaine or Tremaine?
The name I'm representing is Tremaine.
Tremaine. And how do you pronounce your middle name?
J.
Tremaine J. Robinson.
On and for the record, ma'am, I want to say that I want to give notice to reserve all my rights and inform the court that I'm not here to testify or plead. I'm here to make a special appearance to challenge the jurisdiction only.
All right, anything else?
Yes, I would like to see evidence of a charging instrument.
Were you not given a copy of the ticket issued by Trooper Collins?
The charging instrument that I am referring to is a sworn affidavit of the client, of the person that I've hurt.
Now, this is a speeding ticket alleging that you did on March 27, 2023 at 8:48 a.m. operate a motor vehicle in Butler County, Kansas at the speed of 92 miles per hour when the posted maximum speed limit was 75 miles per hour. So this would have been out on the Kansas Turnpike, Highway I-35. Now, what else were you wanting to know, sir, as the allegations against you?
I would like to see evidence of the affidavit of the people that I've hurt. This is a victimless crime if there's no one that I've hurt.
Well, the victim would be the state of Kansas in that you violated the laws enacted to protect the people of the state of Kansas, but this is not the type of crime which would require or have individual names listed. So your next point, if any?
My next point is, as I said, ma'am, I'm not here to testify. I'm not here to plead. I would like to see the affidavit with 2 signatures for the person that I've hurt. If I didn't hurt anybody, there's no crime.
All right, well, I'm going to proceed. The subpoena was issued July 7, 2023 for Trooper Collins. Then on July 31st came a correspondence from the defendant as referred to by Mr. Regier herein. Looks like it's about 7 typed pages, and as counsel said, it's entitled Challenge for Jurisdiction and addressed to Butler County District Court Clerk, Butler County District Court Clerk, Office of the Attorney General Derek Schmidt. And it mentions subtitles under the following case law. I request case 2023 TR 1193 be dismissed. Pretty much standard language that is used by folks who call themselves or are considered sovereign citizens. Quote, it is on this date, July 27, 23, I, Tremaine J. Robinson, it's Tremaine-J, Robinson, in the county of the Seminole of the state of Florida and a zip code, a natural man, attorney in fact, is a living human being who's the beneficiary of Tremaine J. Robinson trademark. Swear that the information in my sworn statement is truthful to the best of my knowledge and understanding. I, Tremaine J. Robinson, beneficiary of Tremaine J. Robinson, revoke my signature on any and all pages of any and all tickets, summonses, contracts, and/or agreements signed by the side of the road in the state of Kansas by Officer Collins K. And so here we are. Now, Mr. Robinson, normally I would be upset that you filed what appears to be in part a motion for discovery and you didn't get that. However, you did not address that document to anybody but Butler County District Court Clerk, Traffic Court, Butler County District Court Traffic Court. You sent one to a PO box in Topeka, and then you sent a copy of it to the Attorney General. But you did not send it to the Butler County Attorney. Therefore, he did not know you were trying to get discovery.
Ma'am, I do have a tracking number that says it was delivered at the Butler Attorney.
Okay, well, that's not on file. What you want to present that at this time?
Yeah, someone signed for it yesterday.
And this document that I'm giving the benefit of, it's a multi-subject document, but this document filed by the defendant that I'm giving the benefit of including what he offers as a motion for discovery was not filed with the clerk until July 31st. So that was after the statutorily required 21 days. And then it was not filed upon the prosecutor who would have, or the witness who would have held any evidence, but rather again on Butler County Clerk in Topeka, Kansas, that to my knowledge doesn't exist, the Butler County Clerk in El Dorado, and Attorney General then Derek Schmidt in Topeka. And that's if it was served, if I take the defendant's benefit of the doubt, that it was saying it was served sometime yesterday before today's 1:30 trial, the court has to decide if that later time was reasonable. And I do not find that it was reasonably served on the county attorney. I am at this point going to say that any last minute motion for discovery is denied and we are prepared to go to trial. Now I've lost you, Mr. Robinson. Are you still somewhere available?
No.
What are you doing there with your computer?
Right now, I was looking for a document, but no, I am not available for trial.
Well, we're going to proceed with trial. So please put yourself back in front of the camera. Follow the court's order or you could be found in contempt. I don't want to do that. Thank you, sir.
Your Honor, in that particular case involved a sovereign citizen where the court noted in the memorandum opinion.
Objection, hearsay. Objection, hearsay.
Case law is not considered hearsay or.
I'm not a sovereign citizen.
All right, he's not a sovereign citizen. Go ahead, Mr. Regier.
Yes, Your Honor. In that case, the Kansas Court of Appeals noted, quote, the defendant thinks the law does not apply to him. He avows that he, unlike other citizens, is sovereign and immune from prosecution. The court went on to address the issue of venue, which the court noted that, quote, venue is generally proper in the county where the crime was committed. I will address that momentarily, as well as referring to KSA 22-2602. Additionally, and perhaps most relevant to this court, the defendant in that case, quote, complains that his objections to the trial court's jurisdiction to prosecute him arise from the claim that he is a sovereign citizen. This is not the first appellate court to deal with such a claim. Another panel of this court used analysis of federal case law to reject a similar claim. And then quoting from Seventh Circuit and Eighth Circuit cases, quote, an individual's belief that his status as a sovereign citizen puts him beyond the jurisdiction of the courts has no conceivable validity in American law. Regardless of an individual's claimed status of descent, be it as a sovereign citizen, a secured party creditor, or a flesh and blood human being, that person is not beyond the jurisdiction of the courts. These theories should be rejected summarily, however they are presented. And with that, I would respectfully call my first witness to the stand.
All right. I do find that this court has jurisdiction and venue to proceed, and the arguments made by the defendant in the 7-page document referred to previously are summarily dismissed.
And did you ultimately write the defendant a citation for speeding?
Yes, I did.
Or an annual redirect? No further questions.
All right, Mr. Robinson, this is your opportunity to cross-examine the trooper. You can question him about his testimony. It's not quite time for you to give your own testimony, so these addresses to the trooper have to be in the form of question. You don't have to question him, but you can. Would you like to?
No.
All right. Mr. Regier, any further evidence?
None from the state, Your Honor.
Okay. The state rests then, Mr. Regier?
The state does so rest, Your Honor.
Mr. Robinson, the state rests. They have presented all the evidence they intend to. Would you like to present any evidence? Again, you don't have to. Your silence will not be used as a sign of guilt. But if you'd like the court to consider your position, I'd be happy to do so.
I don't understand.
Well, do you want to tell the court your version of what happened?
No.
All right. You don't wish to present any evidence then. Am I understanding you correctly?
The evidence that I tried to present, you won't give due process.
Okay. But do you want to give any testimony about the events leading up to this ticket, March 27, 2023?
No.
All right. Well, I will find the defendant guilty of speeding 92 and a 75. The scheduled fine is $87. Court costs are $108. The total due will be $195. Sir, you do have the right to appeal this proceeding. You can appeal it to the Kansas Court of Appeals. You have up to 14 days to file that notice of appeal. Your appeal bond will be in cash, the same as what your court costs and fines are. That's $195. Can you have this paid, this fine and cost paid in 14 days, or do you need some time?
I'll follow up here.
Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing gum, or reading any material. Thank you.
Thank you. This is case number 23-152244. This is Javar Grayson versus Brian Ambrose. The matter is before the court where there is an application for entry of a default judgment. The court has set the matter on in regard to that motion. Your appearance for any attorney who's appearing on either side, your appearance in first instance, please.
Thank you, Your Honor. Christopher Michaels, P83156, on behalf of Police Officer Brian Ambrose. And briefly, there was also the defendant's motion to dismiss in lieu of answer was filed. I don't know if today is the date and time for that as well.
I do have that matter that was filed with the court June the 30th and submitted to the court. So that is an issue that's before the court as well. All right, and do I have Javar Grayson on the Zoom? Say something if you hear it this time.
Yes, Your Honor. Javar Grayson representing myself.
All right, thank you, Mr. Grayson. Good morning to you as
Good morning.
well. So, all right, I see that there is the, let me address the issue of the application for entry of default judgment in this matter. On what basis are you saying, Mr. Grayson, that you should be entitled to entry of default judgment in this matter, sir?
Well, Your Honor, we sent documents into you stating that I'm a national, a Morris American, and this highwayman has no jurisdiction over me. And we sent that information to you, and also sent, I believe I have a court, People versus Battle as a reference in the case.
I think that you're addressing something that don't have anything to do with my question. You
Okay.
submitted to the court a default request. Now, on one hand, you're telling me that the court doesn't have jurisdiction. You're telling me that the court doesn't have jurisdiction, and you're not submitting to the jurisdiction of the court. Then why are you filing something in this court if you believe the court doesn't have jurisdiction? You filed
I'm sorry, the jurisdiction that doesn't have jurisdiction, the 36th District Court, a traffic court, that's not pertaining to you. What I decided to do was send you basically every information to communicate what I've been doing basically in 36th District Court, as well as this procedure.
I'm not a traffic court judge. I'm a civil judge. But I don't know what are you talking about?
Yes, sir. And I understand that.
All right, Mr. Michaels, address yourself, if you will, to both issues. One is the motion for entry of default, and then secondly, which I believe these issues might collide, the motion to dismiss in lieu of filing an answer. Sir, go right ahead, sir.
Thank you, Your Honor. I did receive a copy of the request for default this week, so I had no opportunity to respond. Obviously, the city or the city law department who's representing this police officer filed its motion back in June, dismiss in lieu of an answer. So I don't believe there's any grounds whatsoever for a default judgment. The brief speaks pretty clearly on its face for why a dismissal is appropriate. There is no viable claim stated in plaintiff's original complaint, and since the defendant is was at the time and still is a police officer, he would be entitled to governmental immunity. It appears that it's some sort of dispute regarding traffic tickets or citations that were given for various matters that are currently pending in front of Judge Perkins right now. So it also appears to be some sort of collateral attack against those proceedings, which is under Michigan rules not permitted. So we would ask this court dismiss this case under any of those grounds.
Well, certainly. Let me begin with the default request. I don't see where the defendant is in default in this matter. He's responded to the complaint. Default is when a party fails to act in the judicial proceeding, in a court proceeding, failed to act when they should have acted, and that therefore the court would be required to enter their default because of their failure. Things like failure to answer the complaint or failure to file a responsive pleading. The responsive pleading that was filed in this matter was filed in June. The case was filed, looks like June the 13th, 2023. The motion was filed June the 30th. That's certainly within the time required by law to do a responsive pleading. So I don't see any basis for default. Default is what, like if the defendant did not answer or didn't file a response, then the plaintiff could move for entry of default. I don't see a basis for entry of default in this matter. No, so the motion and application for entry of default is denied. There's nothing about this case that shows that the plaintiff is in default, or for that matter, that defendant is in default on anything. Neither party is in default. The case is right where it's supposed to be, and that is that there's been a complaint filed, and then there's been a responsive pleading. That responsive pleading is a motion to dismiss in lieu of filing an answer. If the plaintiff didn't file straight, that if the defendant didn't file a motion, he would have had to file an answer to the complaint. So when there's a complaint, you got to answer within a certain period of time by either filing a written answer or by filing a motion. Sometimes there's a motion for a more definite statement. Sometimes there's a motion to dismiss because the complaint is deficient or it has some legal flaw involved. This motion to dismiss in lieu of answer is filed alleging and arguing that summary disposition should be granted, or that a motion that the court should dismiss the case because there's no legal grounds, factual grounds for this case to stand on. what is this case about, Mr. Grayson, sir?
It's about a traffic, I guess is a, some type of, traffic ticket. It started off, Brian Ambrosius, stopping me. And I believe I have the right to travel. It started with that. And I do understand, the default judgment, what do you, that you are saying and what it's pertaining to. We are still ready to proceed with the case.
What exactly is your cause of action? Because I don't think that you stated a cause of action that upon which the court could move forward with the complaint.
Well, actually, in traffic court 936 district, there's actions being taken against me as we speak. This is a current case, and 36 district court has no jurisdiction over me. That's why I decided to bring it into civil court common law. And this is a 6-month case that's still going on. So,
all right, Mr. Michaels, get the last word on your motion.
Right, yes, very briefly, there was nothing filed by plaintiff, and it does sound like he's disputing his traffic tickets in this court, which is a collateral attack, which the Michigan court rules and do not allow. So I think that's the best ground to dismiss this case, and we would ask this court.
I object, Your Honor. I'm disputing my birthright. I'm disputing my right to travel.
All right, I got it. All right.
The sovereign citizen mistake isn't usually the first argument. It's refusing to adjust after the court explains why the argument fails. Once a person ties their identity to being outside the system, every correction feels like surrender. Strategically, that creates a bigger problem. The focus shifts from challenging government action to explaining why a legally recognized claim was never presented in the first place.
That you failed to state of action upon which the court can grant relief. This case and the complaint in this matter be dismissed. It's dismissed without prejudice, meaning that if you could formulate a cause of action that is recognized in the Michigan law, then you can bring the matter. If you can formulate case law or some type of law that supports your cause of action. It sounds like part of what is being said here is that as a sovereign person, you have a right to travel and et cetera, et cetera. And there is some basis for the same, but yet there is law that allows for law enforcement to stop individuals that are traveling upon the roadways. And so if that is what the cause of action is that they don't have the right to stop me. There is nothing in Michigan law that recognizes that. If, on the other hand, you find some basis to establish that the stop was in the form of some illegal activity, harassment, some advance against your person that is not permitted under law or done under color of law, but not permitted under the Constitution, then you certainly have the right to bring an action here or in circuit court or in federal court. This case does not have any grounding to it. For that reason, the complaint is dismissed in this matter again, and the complaint is dismissed without prejudice. That would be a final order regarding this particular file. Good day to both sides. I wish you well.
Across both cases, the pattern is almost identical, even though the legal issues are different. One defendant is facing traffic-related charges and spends valuable time separating himself from the legal identity the court recognizes. The other tries to use a civil lawsuit to attack a traffic dispute that is already being handled somewhere else. Different facts, same strategic problem. Courts are built around procedure. Judges may disagree with lawyers. Lawyers may challenge police officers. Defendants may challenge evidence. But everyone has to operate inside the same rules. The moment someone stops arguing the facts and starts arguing that the rules themselves do not apply to them, they usually lose the ability to influence the outcome. Notice what happened in both courtrooms. The judges repeatedly offered a path forward. Opportunities were given to explain facts, present evidence, address the actual allegations, or identify a recognized legal claim. Those openings mattered more than any sovereign citizen terminology because courts decide cases through evidence, procedure, and legal authority, not through declarations of personal status. That's why these hearings are often less about ideology and more about consequences. Every minute spent arguing jurisdiction without legal support is a minute not spent challenging evidence. Every filing that doesn't follow procedure reduces credibility. Every rejected argument narrows the available options. The important lesson isn't that someone disagreed with the court. People do that every day. The lesson is that when a legal strategy stops engaging with the actual issue before the court, the case keeps moving forward without it. And sometimes the biggest consequence isn't what the government proves, it's what the defendant never gives the court a reason to consider.